Right, very busy show this morning. Into our next story we go now, in what could be described as one of South Africa's landmark COVID-19 pandemic court cases. The Health Justice Initiative versus the Department of Health court victory has finally revealed details of agreements between the South African government's COVID-19 vaccine procurement contracts with private vaccine manufacturers and suppliers. In reviewing and analysing the contracts, the Health Justice Initiative found immoral conditions that weighed in the favour of pharmaceuticals, including an agreement that only $20 million of the $40 million advance payment to Pfizer was refundable should the company fail to deliver doses, and Johnson & Johnson's $27.5 million advance payment was not refundable under any circumstances. I mean, this has further brought into question the role of pharmaceutical companies at the time when global countries were trying to contain the spread of the COVID-19 pandemic. But for more on this, and there's a lot more that came out of it, Fatima Hassan, the director at the Health Justice Initiative, joins us this morning. We also invited the Department of Health. They unfortunately weren't available to comment on this. But Fatima, thank you very much. It's good to have you here on the programme.
Thank you, Leanne. Great to be here.
So when we last spoke to you, the Department of Health had not yet handed over the COVID-19 procurement contracts as requested by you, by the court. For you, how much was this not only about COVID-19's pandemic, but about vaccine procurement secrecy and the public's right to the access of information during and after the pandemic?
Thanks. I think you've hit the nail on the head. This really was about the right of people in South Africa to be able to have access to unredacted versions of all the contracts and agreements with different vaccine manufacturers, as well as not-for-profit initiatives that were meant to supply vaccines for people in the global south. So we're really pleased that the Minister of Health did not appeal the judgment. And last week, Thursday in the evening, the Department of Health handed over the first part of the documents, which are the 4 contracts and agreements with Johnson & Johnson, Pfizer, the Serum Institute of India, which was linked to the AstraZeneca vaccine, and then also Kovacs, which is administered by Gavi. And I think the important thing, Leanne, is that these contracts are unredacted. They were given to us in the manner in which they were signed or countersigned by the different parties. And I think that's significant because it does mean that the court's ruling around the lifting of the confidentiality has basically stood ground. And so it's important not just for the vaccine procurement under COVID, it's important for procurement under national health insurance or other, important medication as well for HIV and for TB for South Africa.
Yeah, I mean, when we looked at these revelations, I mean, they're huge, and they not only impact South African citizens, but also businesses who are engaged and form partnership with the Department of Health in securing these COVID-19 vaccines from Kovacs. I mean, that was a word we heard about all the time. It was that worldwide initiative aimed at equitable access to COVID-19 vaccines. I mean, let's get your comments on that.
So Kovacs, unfortunately, we've analyzed the agreement. Once again, we believe that even though Gavi is set up as a not-for-profit initiative, they too were very heavy-handed in the way in which the conditions are drafted. There's provisions for advance payment. There isn't even price certainty in the Kovacs agreement. So there's a minimum and an upper maximum, anything from $10 to $20. But I think the worst thing about the Kovacs agreement is that in the end, it actually overpromised and underdelivered for a number of reasons. And we got a paltry 1.3 million vaccines from them. There was so much of pressure to make the down payment for us to enter into this Kovacs facility. The Solidarity Fund made that down payment. And we'd like to know what happened to the balance of the money, because, ultimately that was public money. I mean, the total bill that we've calculated from the contracts that were given to us, and remember, these are the agreements that were given to us by the Department of Health. They haven't given us any other agreements that show any amendments. So based on the contracts they've given us, we've put the bill somewhere in the region of $700 to $750 million, including for the advance payments and then the actual purchases. But, if we talk about the provisions around the conditions relating to the advance payments, or what would happen if a company doesn't deliver, like you mentioned in your introduction. There's quite uneven provisioning amongst the different contracts. Some contracts say that they'll keep their half at least of the advance payment. Some contracts talk about a lesser percentage. So really, once again, affirming what we said in this multidisciplinary group analysis, that the contracts are very one-sided in almost all respects of the different provisions that we've studied. It basically gives all the power to the pharmaceutical companies, very little leverage to governments in the global south, including South Africa, and very little ability to plan in the middle of a public health crisis. So, the whole point of purchasing agreements is to have certainty around supplies, volumes, price, timing. None of those provisions actually lend itself to proper public health planning in a public health emergency. And I think that's quite unfortunate, dangerous, and something that's going to have to be addressed, not just in South Africa, but for all countries, and going forward as well as in the transparency negotiations happening at the UN and WHO level.
I mean, we have to look at the pricing. I mean, the monies that were spent. I'm going to read it. I mean, you told us all of this, but for those that basically missed it, I mean, South Africa was liable for payments of at least $734 million. That's over 14 billion, including advance payments of $95 million, with no guarantees of delivery. Just one example: J&J charged South Africa $10 a dose. This was 15% more than the company charged the EU, and 25% more than the estimated not-for-profit price. I mean, this is almost cold-blooded murder, isn't it? I mean, the fact that we had to pay such a hefty price on this, and so much more, 25% more than the rest of the world was paying for a vaccine.
Yeah. And I think that what we wanted to emphasize is that these were the prices that were included in the contracts that were given to us and the agreements handed over by the department. And we saw some unevenness in some respects, more than what the UK or the EU or the US, in some cases on par. So I think it points to a global systemic issue of how do you do pricing in a pandemic? How do you deal with preferential pricing, priority customers, and where is the transparency on pricing? So I know that, for example, Johnson & Johnson has said, well, no, actually we charge $7.50, we charge the not-for-profit price, but we haven't seen that global framework. We don't know from which date that was effective from. We don't know if the government received any refunds. So, the true scandal around the pricing is that there were significant amounts of public investment in multiple vaccines, not just for J&J or Pfizer or AstraZeneca, but in a number of vaccine manufacturers' projects and products. And unfortunately, that the risk was socialized, but the profit was privatized. And so you talk about cold-blooded murder, and we talk about gross profiteering, where in many cases, these companies, the vaccines were it was the golden egg. And it gave their shareholders huge dividends. And this is something that needs to be investigated, because it's one thing to say, I'm going to charge you a premium for a product that I will definitely deliver, that I will take all the liability for and all the risk, and so that premium is built in. But in these contracts, all of the liability was passed on to states in the global south, even the indemnification provisions. There was confidentiality provisions, restrictions around whether you could donate or sell the vaccines if you had excess doses to a third country. There was consent provisions inserted, in some cases quite unusual compared to other procurement contracts. So, it doesn't correlate to demand unrestricted ability to charge whatever you want and to do it in whatever way you want, because these are not elected officials. They can't have so much power. I think the most egregious for us, you talked about the Pfizer contract. The most egregious for us was in the J&J contract, where J&J was unable to basically get other governments like the UK or the US or governments in the EU to concede to export bans, but they forced our government to not be able to impose export restrictions, which allowed it to send about 30 million vaccines from the Eastern Cape to Europe when we were facing a devastating series of waves of infections and we were waiting for vaccine supplies. So we got a drip feed of supplies because the priority customers were considered to be Europe. And J&J said to the South African government, if you want vaccines, then you will have to agree to not impose an export ban. And so that undermines sovereignty. This is not just about pricing. This is about how do you have so much power in the room where you say to a government in the global South, in the middle of a devastating global pandemic, take it or leave it.
Sure. It's shocking when you think about it, actually. Did government, and please, if I can ask you very quickly, because I've got two very quick questions to ask you. I've got to wrap the interview. Did the government at the time have any option? Were its hands tied? I mean, were they basically victimized and bullied into this? I mean, if you look back, in hindsight, did the government have an option?
So I think most governments in the global South had very little options. South Africa did push back in relation to the demand for sovereign assets being placed on the table as surety. Latin American governments were not so lucky. And as a result of that, either they didn't get supplies or there was a supply delay. In our case, I think where there were attempts to try and push back, that cost us in terms of months, in terms of delays of deliveries. But you'll remember that our president just recently said that we were beggars in a pandemic and that we had to walk around with begging bowls. The then Minister of Health said that basically South Africa had to choose between their people and the demands of these pharmaceutical companies. So, the question we have is that we have a constitution. We believe in the rule of law. These companies apparently do as well because they keep filing patents in our country and they use our legal system for, to be able to exert their monopoly and their monopoly pricing. So the question is, are we going to allow this to happen again, not just in South Africa, but everywhere else? I mean, what mechanisms are we going to have to regulate this type of conduct? Because tomorrow you're going to have an energy company that comes in and says, well, if you want electricity, then sign these terms and conditions. I mean, it opens the floodgates to really pernicious bullying, as we've argued in the report, and a type of paternalistic behavior where the companies who are unelected think that they know what's best for countries in the global South, particularly in Africa.
Yeah. Parting shot, obviously we look at this and I ask a question, why have you not served at this point legal papers on the pharmaceutical companies like your J&Js and your Johnson & Johnson? Is that something that's in the pipeline? And I know government has until the 29th of September to disclose part 2 of everything that you're going to reveal. But perhaps maybe you can close off with those two points.
So, I mean, finally, we now know who the contracting parties are, right? So when you talk about, well, which company should we have served? We tried to find that out for 2 years and we were told that even that's a secret. So we now have the contracting parties' details. We have their addresses. We also know which jurisdictions they were using for dispute resolution. We know all the terms and conditions of the contracts based on the ones that were given to us in an unredacted version. Yeah, but it wasn't our obligation to include them in the legal proceedings. That definitely is the Department of Health. And we really hope National Treasury studies the report and tries to figure out if any money is owing to South Africa and how better to do procurement. Because if this is only going to be led by the Department of Health under national insurance, then we are really concerned that we will be taken advantage of on a continuous basis. You need a multidisciplinary team within government to be able to deal with procurement at such large scale, involving such substantial amounts of public money. And remember, you and I paid, Indeed. All of us paid for these vaccines. It's our 14 billion rand.
Yeah.
It didn't come from the personal coffers of somebody in the Department of Health. So I think there's an obligation on us to ask the tough questions and for government to actually tell us what is the game plan now. I mean, they can't just sit back and say, well, we were bullied once and sorry, we'll be bullied again. That's Certainly. Not acceptable.
All right, we've got to leave it there. Fatima, thanks for the fight. Thank you. On behalf of South Africans, we look forward to catching up with you. We know the 29th of September is that second tranche of documents that we should be getting information from. Fatima Hassan is the director of the Health Justice Initiative, talking to us about their analysis and findings that were contained in 4 COVID-19 vaccine procurement contracts between the South African government and global manufacturing and distributing companies.